back, I believe. So let's proceed. Am I audible?
Yes, Prof. You are.
Yes.
Okay.
Yes,
And
yes, you are audible.
You can see the screen, right? You can see the screen.
Yes.
Okay, great.
Yes.
Now, I think I'm just reminded now that during the break time that we also need to be careful about something and guard against it as scholars, as lawyers, as law students. There is a view which I consider to be a very silly view that tends to do rounds, and it says that in matters of this nature, that would include the former president, for instance, that when you are saying that a court has wrongly found on something, it means that you are you belong to a particular camp, for instance, that you are supporting Zuma, for instance, and so forth. And I'm saying it is quite silly because it deliberately seeks to misunderstand our role as lawyers and our role, at least for some of us, as critical legal scholars. If something is wrong, if something is basically unconstitutional, we point it out, and we should point it out without fear that we may be branded politically as belonging to this or that. It is a very silly view that should be dismissed with contempt, as we are dealing with contempt today. It only deserves contempt. We are informed by the Constitution and nothing else. Now, the main critique that I have with the main or the majority judgment in the case is that it is based on an assumption that certain rights can be waived. And I think there's also a confusion to a certain extent between the supremacy of the Constitution and the supremacy of the Constitutional Court. Now, we know very well that Section 2 of the Constitution deals with supremacy, and it states that this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. That's Section 2. So it says that the Constitution is supreme. And if you go to, once again, to Section 8 of the Constitution, it says that the Bill of Rights applies to all law and binds the legislature, the executive, and the judiciary, and all organs of state. So the judiciary is bound by the Constitution. The rights that accrue to us, for instance, as citizens, are as a result of based or informed by the Constitution. It is not courts that give us rights. It is the Constitution that gives us rights. So the Constitution binds the judiciary at the same time. That's one part of it. And the other part of it is that obviously rights cannot, constitutional rights cannot be waived. But you will see that there's a bit of a problem in the paragraphs that I have selected. In paragraph 9, the majority judgment says that it goes without saying that neither the public's vested interests nor the ends of justice would be served if this matter were to be required to traverse the ordinary and lengthy appeals process that would render the litigation protracted. What is wrong with litigation being protracted? It is in the nature of litigation. The issue is not the protractedness of litigation. The issue is the safeguarding, the protection, and promotion of the rights that are in the Constitution. Paragraph 48, once again, the majority judgment says a coercive order would be both futile and inappropriate in these circumstances. Coercive committal through a suspended sentence uses the threat of imprisonment to compel compliance. Accordingly, a suspended sentence, being a coercive order, would yield nothing. It's a statement that is quite confusing. Again, the majority judgment says that, moreover, I cannot ignore the fact that I have yet to come across a case in which a solely punitive order of immediate committal has been made, or where punishment is not calculated to coerce the recalcitrant to comply with the initial order. Paragraph 63, the majority judgment says, since all of this led this court in the direction of an unsuspended order of committal, this court was alive to the need to consider and indeed safeguard Mr. Zuma's constitutional right to freedom. After conviction in a conventional criminal trial, it is a violation of an accused person's right to a fair trial under Section 35 of the Constitution to proceed to impose a sentence without affording him an opportunity to say something in mitigation of sentence. Now, we will see later on that this statement is problematic. It is problematic to the extent that it assumes that you can leave some rights and say, but I've offered you this once, so what is your problem? Paragraph 65. The court says, however, the majority judgment says, however, this is not a conventional criminal trial. A respondent in contempt proceedings is not an accused person, as envisioned by Section 35 of the Constitution. And I think here, those who watched the rescission hearing would have seen that as far as I'm concerned, I think Advocate Dalimpofu was quite brilliant. He was quite brilliant in his exposition of the fact that ultimately, at the end of the day, it's not an issue of form, but it's an issue of substance. Paragraph 68, the majority judgment says, therefore, although a contemner is not an accused person, as envisaged by Section 35, the fair procedure required by Section 12 may, depending on the circumstances, necessitate a process that is akin to that afforded by Section 35. And here I have already mentioned that constitutional rights cannot be waived. The court cannot choose which rights are going to be applicable here and which rights are not going to be applicable there. That is not the role of the court. Unless, of course, the court invokes Section 36. Paragraph 70, the majority court says, by issuing the directions, this court afforded Mr. Zuma entitlement to a fair process dictated by Section 12 of the Constitution in a manner comparable to the Section 35 residual fair trial. And as I say, the big one in paragraph 75, wherein the majority judgment says it is uncontroversial that he was not afforded each and every single one of the protections of Section 35 because he was not an accused person and was never entitled to all of them. I think that for me is a mind-boggling conclusion. And it is plainly wrong, it is plainly unconstitutional, and it is untenable for reasons that you will see as we proceed. So, Theron J, Justice Theron, wrote what I consider to be a masterpiece of a dissenting judgment that for me should have been a majority judgment. It was a calm judgment. It was a well-reasoned, solid judgment that sought to actually suffuse the entire matter with the essence and spirit of the Constitution. And very interestingly, I'm not sure if some of you are aware that it is probably the first time in the history of the Constitutional Court that a dissenting judgment would call the majority judgment unconstitutional. That's unprecedented. It's a big statement and should not be taken lightly. Theron J starts by saying, is it constitutionally permissible to impose punishment in the context of civil proceedings where the initiating party disavows its interest in obtaining compliance with the original order? She says that, in my view, it is unconstitutional to the extent that it violates Section 12 and Section 35(3) of the Constitution to order punitive committal for civil contempt in motion proceedings where no remedial or coercive relief is granted. She says, in my view, if a coercive order of committal will likely be inappropriate, the proper order would be an order referring the matter to the DPP so that Mr. Zuma's case can be tried according to criminal standards and subject to the necessary protections. In other words, Mr. Zuma's constitutional rights cannot be waived. She continues, if, as a constitution, sorry, sorry for, I think I've just mixed up my slides there quickly. Yes. Right. She continues by saying that a coercive order seeks to enforce compliance with the original order for the benefit of the successful party. In order for the coercion to be effective, a punitive sanction is suspended on condition that the contemptor complies with the original court order. Now, there's a reason why I'm reading this and taking this as is from the court, so that there's a tendency to say that people have been misinterpreted and so forth and so forth. So it's quite important that we deal with actually what was said in the very words that were used. And Justice Theron proceeds and says that in a very strange twist, the Commission does not in these proceedings ask for coercive order to compel Mr. Zuma into complying with this court order. Instead, it asks for the unsuspended order of imprisonment in the context of civil proceedings, which is not designed to induce compliance, This is an order which, as far as I'm aware, has not been made in the history of our jurisprudence on civil contempt. She proceeds by saying that that is the minority judgment or the dissenting judgment by Justice Theron. Justice Theron says that exceptionality and gravity of Mr. Zuma's contempt and his refusal of every procedural olive branch offered by this court does not cure the unconstitutionality of the proceedings.
He's muted.
Yes.
Yes, we can't hear anything.
Prof. Shai, please unmute. Somehow
Yes. Can you hear me now?
perfectly.
Yes, we can hear you.
Yes, we can hear you now.
Someone keeps muting me. I don't know whether it's automatic or what. Yeah.
I think it's automatic.
Yeah, I think it's automatic too. So, if punitive steps are indeed warranted by criticism so egregious as to demand them, there's no reason why the ordinary mechanisms of criminal justice system cannot be employed. A summary contempt procedure intended purely for penal purposes.
Prof is muted. Please come back.
Prof. Shai?
Yes, I'm back. Yeah,
sorry, you're going to have to keep pressing that button.
Yeah, I'll just keep checking it. Thanks. Yes. And this is the devastating part of the minority judgment. Justice Theron says that the main judgment, by its own admission, has pushed the bounds of our law of contempt in order to meet these exceptional circumstances. The danger of this approach is foreshadowed in the well-known aphorism quoted at the outset of this judgment. It has led to the creation of bad law. As I demonstrate, the law is not just bad, it is unconstitutional, period. The dissenting judgment is saying to the majority judgment, the main judgment, that you have created bad law. Not only have you created bad law, it is a law that is unconstitutional. It is unconstitutional because of, amongst other things, a person's rights cannot be waived. Huh? So why is the majority judgment bad law? And why is it unconstitutional? Not only according to Justice Theron, but according to some of us. The first is that the majority judgment seems to assume that constitutional rights can be waived, and this has no jurisprudential foundations. It is unheard of. The second is that it is illogical to reason that a party's entitlement to a specific procedural protection depends on whether she has taken advantage of another separate procedural protection. These are the reasons why the majority judgment is bad law, why the majority judgment is unconstitutional, and why it is untenable. In a constitutional democracy, so the essence of the court's reasoning is firstly that Mr. Zuma was not afforded each and every single right in Section 35 because he was not an accused person and was never entitled to all of them. And secondly, by issuing the directions, the court afforded Mr. Zuma entitlement to a fair process dictated by Section 12 of the Constitution in a manner comparable to Section 35, residual fair trial. This is the rationale, this is the reasoning of the majority judgment. So in essence, Mr. Zuma waived the rights the court afforded to him. And I argue that the very first problem with this logic, with this reasoning, or with this rationale, is that the court cannot grant Mr. Zuma rights. The rights we have are granted by the Constitution. We derive them from the Constitution and not from courts. And that is a very clear distinction. It's not a very complex distinction there. It is a very clear distinction and easily discernible distinction that the rights we have are granted by the Constitution and not the courts. No constitutional provision is made for waiver. The waiver of constitutional rights should never be tolerated. There is no such a thing as waiver when it comes to constitutional rights. To talk of constitutional waiver is to make a categorical mistake. I am relying on this. I'm relying on an article that was written by Stu Woolman, STU, that is the name, Stu Woolman, and the title of the article is Category Mistakes and the Waiver of Constitutional Rights, a response to Diksha Bana on Buckhazen. It's a very interesting and well-written short article that those who have time should look at it, wherein he goes to town about waiver. He says that in a regime of rights in which the Constitution is the supreme law, the only real question is whether the Constitution permits certain kinds of action or proscribes certain kind of action. Once a court determines what the Constitution allows or does not allow, there is no longer any question of waiver. You either have a right to do something or you don't. So my concluding observation on the two judgments are that the judicial authority should not be protected at the expense of fundamental rights. The rule of law is about more than the obedience with court orders, and its robustness does not depend solely or even primarily on whether litigants who flout court orders are punished swiftly and unconstitutionally. The rule of law as a fundamental norm must be understood within the context of an open and democratic society premised on human dignity. Public opinion focused more on the majority decision to sanction Zuma without, and this is my argument, without attentively and slowly reading the essence and rationale of the minority judgment. So there's been what I would call inordinate excitement that confuses the person of Zuma and the Constitution. So I'm arguing that had we been very slow and attentive in reading the essence of the minority judgment, we perhaps may agree that indeed there is a case for precision in this matter. Because the majority judgment is unconstitutional. And Justice Theron asks, he says, why has the Commission instituted civil contempt proceedings when it does not seek to protect its rights or interests under the order granted by this court, and it appears to gain no benefit from these proceedings? And by the way, just for interest's sake, the Commissions Act that is being spoken about is the Commissions Act of 1947, right? And the offenses that it creates are found in Section 6 of the Commissions Act. And it is interesting that it still talks about being just a sec, I'm just looking for. Yes, it still talks about the fact that one not having done certain things shall be guilty of an offense and liable on conviction to a fine not exceeding £50 or to imprisonment for a period not exceeding 6 months, or to both such fine and imprisonment. That's the Commissions Act. It still talks about a fine not exceeding £50. It's 1947. So this is the Commissions Act that is being referred to in this case. So, though the substratum of this dispute with Mr. Zuma was non-compliance with the Commissions Act, the Commission effectively has sought to transform the dispute into one between Mr. Zuma and this court. That is in paragraph 265 of the minority or the dissenting judgment by Justice Theron. Now we need to look at, for me, my argument, what I argue is that we need to look at the notion of contempt within the context of what Davis and Clare call a transformative methodology. Firstly, we need to recognize that contempt is a common law offense and therefore should conform to the Constitution. So there's a spelling error there, but therefore should conform to the Constitution. Should conform to Section 8 of the Constitution and Section 39 of the Constitution. Or at least that should be the context within which the notion of the common law offense of contempt is looked at. This section 8 and 39, 8.3 and 39 of the Constitution are called development clauses. And these development clauses place South African judges under a duty, so argues Davis and Clare, under a duty to promote constitutional values rather than merely to assure the conformity of judge-made law to constitutional strictures. It is important that when we deal with the common law, of which contempt is a part, that we reimagine, consistently reimagine. And as Davis and Clary say, reimagining the common law is critically important to the success of the constitutional enterprise as a whole. The development clauses link the reworking of the common law to the transformative project of renovating South Africa's legal infrastructure so as to establish a society based on social justice and improved quality of life for all citizens. Now, for those who may not have their constitutions with them, Section 8(3) of the Constitution says that when applying a provision of a Bill of Rights to a natural or juristic person in terms of subsection 2, a court, in order to give effect to a right in the Bill of Rights, must apply or, if necessary, develop the common law to the extent that legislation does not give effect to that right. And the section also says that the court may develop rules of the common law to limit the right and so forth, right? And section 39(2) that I'm referring to here states that it states that when interpreting the Bill of Rights, a court, tribunal, or forum must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. It must consider international law and may consider foreign law. Now, 39(2) then says that when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. So reimagining the common law is critically important to the success of the constitutional enterprise as a whole. These clauses that I've just read, they are called the development clauses. They link the reworking of the common law to the transformative project of renovating South Africa's legal infrastructure so as to establish a society based on social justice and improved quality of life for all citizens. The mandate of Section 39(2) is to reimagine all law in the spirit of Ubuntu. The common law is not to be trapped within the limitations of the past. It needs to be revisited and revitalized with the spirit of the constitutional values defined in and with full regard to the purport and objects of the Bill of Rights. And in that context, looked at in that context, I argue that the majority in the Zuma case failed in this constitutional mandate. Now, it did not apply what Davis and Clary call a transformative methodology. A transformative methodology means an approach to legal problems that is informed by the values and aspirations of the Bill of Rights, and specifically by the constitutional aspiration to lay the foundation of a just, democratic, and egalitarian social order. It brings these values to bear on a context-sensitive view of the case, seen in the light of all pertinent ethical and socio-economic considerations, as best this can be determined. Right? Now, the majority judgment, as I indicated earlier on, in paragraph 1, starts by saying that it is indeed the lofty and lonely work of the judiciary, impervious to public commentary and political rhetoric, to uphold, protect, and apply the Constitution and the law at any cost, at any and all costs. That's what it says, the majority judgment. That's its opening statement. Now, I'm saying compare that and with what Davis and Clark are saying. They are saying that a transformative legal methodology brings these values to bear on a context-sensitive view of the case, seen in the light of all pertinent ethical and socio-economic considerations. At the same time, the solutions that a transformative methodology generates are not eternal. Its results, that is the results of a transformative methodology, are always understood to be provisional. That is, always being open to reconsideration and contestation as experience progresses, understanding deepens, and or circumstances change. Courts of law or courts of justice? That's one question that we should ask ourselves. So, does it mean, in light of what we've just said, that we have political conservatism in the judiciary? Well, Davis and Clark, writing in 2010, say that at present in South Africa, political conservatives, referring to the United States, they say that at present, political conservatives have captured much of the US judiciary. That was in 2010 when this statement was issued. Right. Now, based on the majority judgment, this statement could have been regarded or may be regarded as scurrilous and therefore contemptuous. There's that possibility. I may be wrong, but that is precisely why I was arguing that some of the sentiments in the majority judgment are dangerous, because they may be interpreted. The majority judgment may have meant well by saying that we need to be careful about how we critique the judiciary, but perhaps the manner in which it comes out may actually create a very dangerous situation where a statement that Davis, Judge Dennis Davis, those who don't know who I'm talking about, and Calclay, a statement such as political conservatives have captured much of the US judiciary. Such a statement may be regarded as scurrilous and therefore contemptuous in the context of the majority judgment. Now, that for me is a concern. It's a big concern. In South Africa, they say, juries continue to deploy traditional and even antiquated methods of legal analysis. They wrote that in 2010, and I suggest that this is largely still the case. And I refer you there to the case of Napier versus Parkhazen and the case of Brillenkamp versus Standard Bank, wherein in the Brillenkamp versus Standard Bank case, it was said that the appellants, that is the SCA, says that the appellants were unable to find a constitutional niche or other public consideration justifying their demand. Right. Now, it goes back to Section 2 of the Constitution, the Supremacy Constitution. It goes back to what I referred to earlier on in an insolvency matter. I ask a question, is there anything that can escape the Constitution? I don't think so. We do not have many laws in this country, many systems of laws. As far as I know, we have one system of law which is informed, derived from, guided by Constitution. Now, when it is said that there are things that can escape the Constitution, that we are unable to find a constitutional niche, that for me becomes slightly concerning in light of the supremacy clause in the Constitution, provision in the Constitution. They further say that jurists deeply committed to transformation returned in this country reflexively to fall back upon intellectual instincts inculcated in the course of their pre-constitutional professional training and socialization. That's part of the problem, and that is part of the problem with what we discussed earlier on in relation to the notion of legal culture. So they are basically saying that there is a problem, again, of legal culture, right? Now, the Bill of Rights applies to all law and binds the legislature, the executive, and the judiciary, and all organs of state. In essence, my argument is that we firstly need to understand our role as scholars and as critical scholars, some of us. We need to understand that the role of critique is still very important in this country. We also need to appreciate, linked to that critique, of course, must be informed. We need to understand that we need to, at all costs, I would argue, protect our judiciary. And part of protecting our judiciary is critiquing it from an informed point of view. I argue that the majority judgment, for reasons that were advanced by the minority judgment, and for other reasons that I've pointed out, that the majority judgment is unconstitutional. And I think that that came out very clearly and very forcefully, very pungently, very cogently came out when Advocate Dalimpofu, SC, presented his oral argument. And I also suggest that the decision by the majority court is unprecedented for a number of reasons. For the reasons that it was unconstitutional, but also for the reasons that it sought to make a decision on which rights are applicable or not. And that is different from saying which rights can be limited or not. Courts can do that. But courts cannot say that there are certain rights here that we are not going to give you because you do not deserve them or because you behave like a spoiled brat. We are not going to give you these rights. You are not entitled to these rights. And I think that is, as I said, that is not only unconstitutional, it is dangerous. And I agree fully with Justice Theron when she says that that's bad law and therefore unconstitutional. And on that note, I it's a very difficult and long discussion that we can have. And I've tried my best to limit, but also the reason why it would have taken as long was because I prefer that we rely exactly on what the court said without even paraphrasing it, both the majority and the minority judgment. And I therefore conclude by thanking you and saying that I am certain that the majority judgment must be, I'm certain that it must be rescinded, for it creates dangerous law, it creates dangerous precedent, and it is unconstitutional. And those are my submissions, and I do not think that that should be or ought to be the role of the judiciary in this country. And I will stop there and see if we can have a discussion for the next 30 minutes or so. I don't know if Professor Stone, do you want to me to proceed with, or you want to handle the question answer, or what? You can guide me on this one. Or should I just
yes,
proceed?
I'm not sure. I'm seeing a couple of hands up.
Yeah.
So, and I don't know if you can see them on your side.
I can see some.
Yes, I also can only see some, but let us try and work systematically, and I don't know whose hand was up first. So I'm Takatso. I'm just going to start randomly from where I could see. Takatso, are you ready with your question? Did I see it? Was it Takatso? Okay, we're not hearing from Takatso yet. So then Shepherd Kamudyariwa.
Can you hear Takatso now?
Yeah, I can hear Takatso.
Okay, great.
Okay, thank you. First, Prof, thank you very much for this presentation. But my question is, of course, I understand your conclusion that you would propose that the judgment be rescinded. But what are the implications should the Constitutional Court not rescind their judgment, but uphold it? What are the consequences for the Constitution itself and the rule of law, in your understanding? Thank you.
Thank you, Takatso. I'll just take perhaps maybe 5 questions at a time.
Okay, that sounds good. And then maybe those people who've asked the questions can put your hands down, because I think that would allow me to then see. Okay, no, I can see some. Zanele Mpanza, are you ready with your question?
My question is that if the Constitutional made a judgment which is unconstitutional, what is the way forward to reverse the error? Because it is an error which they have made. And what is the way forward to give Mr. Zuma the remedy of saying, look, we've made an error, and upon the judgment of this bad law which was sanctioned unto him. And again, a question of this majority judgment. What is a better way looking forward in the future when sanctioning a judgment, you would also look at other options of not infringing the right of somebody because I believe the Bill of Rights says all laws apply to apply to executive, it's binding to executive, judiciary, and everybody. So why would somebody be his right being infringed and all that? But those are the questions that I have. Thank you.
Thank you.
Then Shepherd had his question, I can recall.
Yes. I don't know if you can hear me.
Yes.
Yes. Mine, I don't know if I'm throwing a spanner in the works or I'm making your job a bit more longer. When I was reading the case and what led up to the judgment, I was, and when I was watching the rescission case as well, I was actually wondering why Advocate Mpofu had not actually asked for the whole case to be dismissed and the judgment rescinded on the basis that Jacob Zuma's rights to be presumed innocent had been violated. Why I'm saying they've been violated is because he was asked to mitigate before he was even found guilty, and that actually colored the whole process. And thus, he was actually not presumed innocent. He was actually being asked that, tell us what sentence we want to give you. And when he refused, it also contributed to the perceptions of non-cooperation that subsequently led to some of the issues that were raised against him. It's just an observation. If I can invite comments on that one. Thank you.
Okay, thank you. The fourth.
Yes. Okay, the fourth will be from Walter. I know he always asks very complex questions. Walter?
Okay, thank you, Prof. A wonderful presentation. It's given that the judges in general are wrong at this juncture, but what has always bothered me is the question that every decision by the legislature and executive, it's subject to the constitutional master. What is then the rationale? I'm not worried about the wrongness, but I want to understand what is the rationale behind the notion of majority judgment versus minority judgment. I'm saying this because this is not the first case that the apex court of this land makes a mistake. Of course, this one we have not received a judgment, but there was one, I just forgot whether we treated a question of res judicata. I'll just remember the case. It's a vendor surname. The apex court made an error with regards to that fellow. And then this is now the repetition of that. And all that we are told is that if the majority of judges who are, as you put it, understanding the Constitution unconstitutionally, they are not subjected to the constitutional master, but to the majority ruling. I just want to understand what is the rationale behind the test of the majority ruling as opposed to the test of the constitutional master that everyone is subjected to. Thank you.
Prof. Shah, would you like to respond to those at the moment or carry on receiving questions?
No, I can try the four questions that have been asked.
Okay, thank you.
The difficult questions. And I do not bring truth to the questions. I only bring my observations. The first one, Takatsu says, talks about the implications if judgment, if the judgment is not rescinded, and what becomes the way forward. You know, one of the, I suppose it didn't come up clearly in the in the presentation, particularly when I made reference to Section 8 and Section 39. Section 8, I think it's Section 8, 3 and Section 39. I think it's Section 39. Three. And the other section, I think is Section 8, is that it is my submission that we have missed an opportunity to develop the common law of contempt. I still am of the view that it is quite a bit of a mishmash at the moment. And therefore, this should have been an opportunity for the Constitutional Court to act in accordance with Section 39 and Section I'll recall the section just now, and Section 8(3) in this instance, to ensure that the common law in relation to contempt is in accordance with the essence and spirit of the Constitution. Whether the legislature can step in to codify it, I do not know. However, it is my view. I mean, there have been cases, obviously, I mean, that have already decided that it is constitutional, right? However, I still am of the view that there is no clarity. And that's a separate discussion when we purely focus on the common law crime of contempt. The implication, if it's not rescinded, is very simple, that it becomes precedent. And the only way that you can change it is through legislative intervention. And that's just how it is. And in relation to Zanele, and Walter, I think there's a sense in which the two questions talk to one thing, if I'm not mistaken. I mean, it is accepted that judges are mere mortals, like all of us, and therefore in certain instances are prone to error and mistake. And it is out of this recognition that you have certain procedures and processes that allow for the changing of or rectification, or whichever way you want to call it, of a decision. You have an appeal process that can do that. In this instance, part of the problem, part of what was raised by both Justice Taron and by the applicant in the rescission hearing, is that by the court making itself a constitutional court making itself a court of first instance, that created a bit of a problem, you know. But that is besides the point. The point is that you also do have the rules of court, the uniform rules of court, which, I mean, you go to Rule 42, that creates an opportunity for a judgment that was erroneously sought and erroneously granted to be rescinded. So there are mechanisms that allow for a decision to be reversed other than appeal, for instance. So Zanele, the other problem, obviously, in relation to what you're saying, is the notion of legal culture. If I'm not satisfied that generally our judiciary is sufficiently suffused. I mean, there are many other brilliant judgments, make no mistake, but I'm not sure if we are sufficiently suffused with the requisite understanding of the spirit and transformative essence of the Constitution, what it requires us to do in relation to the transformation project in this country. So it's a discussion that we ought to continuously have. And the rationale behind the majority judgment and the minority judgment, Walter, I'm not sure if I understood your question very well, but it is what it is. The rules are that if you have more than one judge having to sit on a matter and make a decision, the majority decision is the one that creates a precedent. So the question perhaps is, in an instance or in a situation wherein you have more than one judge having to sit on a matter, how does precedent get created? It is created by the majority judgment. Perhaps maybe what you are asking is not so much a question, but rather a critique of whether is this how we should do it. But that's how it's done. I mean, even in a jury system, I mean, the majority holds. So majoritarianism is part of a democracy. So I don't know how else I can answer your difficult question on that. Why, Shepard, I did not understand your question, but I understood it more as a comment in relation to the strategy that was used by Advocate Mpofu and Advocate Masuku. Every advocate would deal with, from a strategic point of view, with the matter differently, you know. So how they did it is a matter of strategy. The arguments that they raised is a matter of strategy. The cases that they relied on is also informed by their theory of the case and the strategy of the case. I mean, the strategy of their case. So I can't speculate as to why is it that they said this and not said that, you know. But as I am saying, these are very difficult questions, and it's quite difficult to they're legal questions, you know. So as they say that with legal questions, they're not like fish and chips, you know, that you can simply dish out. They mostly require that a person can ask you a question, and it may require that you go back and say, okay, by the way, what would be the situation under the circumstances? But I can only say that that's the best that I can give from where I sit at the moment. Difficult questions and interesting questions, but if I have not answered, I do not claim to know all or to have all the answers and to know all the law. So I can only say what I know. As they say, you can only know what you know. You cannot know what you don't know. In my defense, yeah. But thank you for now. I mean, some of the questions, as I said, are more comments, and comments are also welcome. Thank you.
Okay, let us try and get another round. I saw Elias's hand was up. And then Johannes. So let's start with Elias.
Okay, thanks all for affording me this opportunity. My question is, it seems as if some of Mr. Zuma's rights were transgressed, if I may put it that way. So, if the Concord rescinds its judgment, can or will Mr. Zuma be able to institute legal proceedings against the state for wrongfully imprisoning him? Thank you.
Johannes, are you ready to ask your question?
Yes, I am. I would just like to start off in thanking Prof. Shai. I really enjoyed the talk so far. And I would just like to play a bit of devil's advocate. And I don't usually use the argument of authority, but I was just wondering how could 7 of the 9 judges ruling on this matter, that's some of the most respected and qualified judges in South Africa, all have a wrong opinion or be unconstitutional in their judgment. It just doesn't really make sense to me how 7 of the 9 judges sitting on this case could make such a huge error in this respect. And secondly, I would just like to ask, I don't really know if it's appropriate, but I think most of the people on the chat is still students. So if it's possible, as I say, I don't know if it's appropriate since this is a guest lecture, but if Prof. Stone, you could also give your educated opinion on the matter, yeah, I would really enjoy it. Thank you.
Yes, I'm still listening to I got the first 2. Maybe
Yes,
another.
and then I had a perfect list of all the questions, and then I changed screens, so then I lost the thread of whose hands are up. Okay, I've got it again. So Tologelo, I think you were next. I'm just now going based on the list I've got. Tologelo, sorry.
Am I audible? Hello, am I audible?
Yes, you are.
Yes.
Oh, all right, thank you. So Prof, I have a couple of questions, right? My first question would then be if the Constitutional Court was to rescind its judgment on this particular matter, what would be the impact or the implications rather on the integrity of the court and the people's then trust and belief in our judicial system? My second question tends to what you said earlier in terms of legal culture, to say if part of the problem with our legal culture has to do with the fact that we base a lot of our a lot of our law on common and Roman Dutch law, does that mean we'll never really get to the point where the legal culture in this transformative constitutionalism then goes forward, because our law will always be based on common law and Roman Dutch law? My third question and my final question is that you mentioned that part of the reason that we are here and we see everything unfolding is because our government has failed the transformation project. So then, can we say, based on how you define transformation and constitutionalism and how different they are, and South Africa being a transformative constitution, is it then a practical thing? Is us having a transformative constitution a practical thing, because we clearly over 27 years have failed to then implement it? Thank you.
Kabelo Matete, do you have a question? Kabelo? Okay, I'm not hearing from Kabelo. Let me try Tawanda Madamombe.
Yeah, hello. Can you hear me?
Yes.
Yes, can hear you.
Okay. what I have faced are comments that I just wanted to put from what I've discovered in the South African judiciary. I think the system whereby we don't really know the philosophy behind the judges that we have, like which political parties they support. It's like they are treated like, above human beings, like they cannot support a certain political party. And I think there's something wrong with that, because I'm taking this from the American system, whereby a judge is known to be a liberal or a conservative from the start. And then they now focus on the what? On their, how they apply the law, okay, and their impartiality, regardless of what they support. So I think that's one of the problems that we have. Then coming to the merits of the case, what is concerning to me is that there was an argument that was raised with regards to the issue of a motion proceeding being a trial or not. So I don't know, like, what was your take, Professor, in terms of a motion proceeding that was raised by this Rasta lawyer, who was arguing that a motion proceeding is a trial in terms of Section 12 of the Constitution. So I would like to ask you, what's your opinion on that?
Hello, Prof. I'm available. Kabelo here.
Perfect. Yes, please go ahead.
Yes, thank you for the platform. I do apologize. I did not hear majority of the presentation. I was struggling, but having read the case, I have a few questions. And my first one is, as my brother before me just alluded, regarding motion proceedings. I am of the view and understanding, according to the law, that a motion proceeding can be presented, or rather is an evidence regarding a person that is a litigant in a particular case, especially if, as a way of bringing evidence forward, especially if the person is not testifying with regards to what Zuma said. So my first question to Professor Shah is this: is he saying what he's saying because he thinks the majority erred in their judgment of Mr. Zuma, or he's arguing the right part? And if it's a matter of the right, the minority alluded to Section 12 and 35 as part of their reasoning behind Mr. Zuma's unconstitutional or constitutional rights being infringed. And I'm of the opinion or understanding that if a person is subpoenaed, or rather they ought to appear between a particular commission or even a court in this instance, under subpoena, their rights as a result, they have no rights because they have to testify. So using Section 39 and Section 8, isn't it then that Mr. Zuma indeed infringed upon the rights of South African citizens by refusing to testify himself? Because then he had no right and therefore we had the rights. So the majority in their judgment definitely did not err, in my opinion. As so, the minority agreed that he was in contempt of court. And secondly, if the Constitutional Court does not rescind Mr. Zuma's rescission, is Professor Shah of the opinion that the judges are tainted, or that they still continue to err, and the precedent set is a precedent that's not going to benefit anyone in the long term? Thank you.
Okay. Yeah. So,
Agreed. Difficult questions. I'll give you the floor.
yeah, as indeed someone said probably, that you are also to hear your views. I mean, the first question, it's quite simple. You cannot sue a court for wrongful imprisonment. I don't know how else I can put that. It's based on logic. It's based on common sense that you cannot do that. We can sue the police for wrongful imprisonment, but it's perhaps I need to understand. I missed the rationale behind the question, but the short sweet answer is that that is undoable. It cannot be done. And the issue relating to, I think it was Johannes who asked, how can 7 judges all have gotten it wrong? I think, Johannes, the issue is not so much about the number of judges that will have gotten it wrong. That should not be our point of departure. As scholars, as constitutional law students, and so forth, our point of departure should be whether the decision of the 7 or the 8 or 9 or 12 or 1 is in accordance with the Constitution. That is the overriding and the fundamental question. So the issue of numbers should not be what informs us about or what informs our critique. So there's a sense in which it is a wrong question. The right question is the Constitution. We are arguing, some of us, that our point of departure should be the Constitution. And we use the Constitution, including previous decisions of the court, to evaluate whether the majority judgment was legally correct in this instance. It cannot be that we then say that because it was 7 and therefore how is it that so many people could have gotten it wrong? Yes, it is possible that many people can get it wrong in any given circumstances based on a number of reasons. So the short answer is that it's not about the numbers. It's about your assessment and your analysis of the Constitution, of this previous decision of the Constitution, and so forth. That should inform your conclusion, and your conclusion can therefore not be informed by whether it was 7. From a constitutional and point of view, and there's a constitutional, I'm not sure where you are currently as a constitutional law student, so if the question was, why is it that, tell us your view about the case, and your answer is that I think the decision was correct, and you then say that I think it was correct because majority say it was correct, that would certainly not be sufficient. If you say that they were correct because of the fact that they dutifully and faithfully applied the spirit and essence of the Constitution, now that's a different discussion. So the issue is not about the Constitution. That's what we are discussing, and that should be our main concern. In terms of the integrity of courts, if the decision is rescinded and so forth, I don't think this is going to be more about the integrity of the court if the decision is rescinded. Remember that decisions get rescinded all the time in courts. So what is happening today in relation to the application for rescission is nothing new in this country. It happens all the time, and that does not talk to the integrity of judges. It simply means that at a given point, a particular judge or particular judges may have gotten it wrong in relation to this and so forth. So it doesn't really. They are solid judges, by the way, they are great judges, I would argue. It's just that it is my opinion, and at least some of us, that in this instance, they may have confused the Constitution and the person of Zuma, that they had an inordinate focus on what they thought was scandalous attacks and other things by Mr. Zuma on the court. But I do not think that otherwise they are tainted and are going to be tainted and so forth. No, I think they're great judges. We are scholars, so we are critiquing their judgments. You know, that's what we do. When we are scholars, we don't accept anything because we must accept it. You know, and that's one other important issue that it must be raised, that the approach really in learning is not to simply accept, right? Is to accept in certain instances, but also exercise your faculties and critique if and when you are of the view that a particular decision is wrong. Judges are human, they make mistakes, but in terms of our constitutional democracy, having said that, we still maintain that the judiciary must nonetheless be protected and be respected, because in the absence of that, our whole constitutional edifice will come crumbling down. So integrity, no problem. There's not going to be any effect on that. The common law issue that was also asked. Remember, there are different views about the common law. There are scholars and some of the judges who have said that we should have started afresh in relation to the common law, for instance. You know, we should have just started afresh with not only the common law, but with the law. We should have said that now that we have a constitution, right, we're going to start afresh and make sure that each and every law is new and conforms to the constitution. But some are saying that that would have been practically impossible. That is the reason why it was then decided that what we have, we have. However, what we have must nonetheless conform with the constitution. So that is what the constitution says, and there are different views in relation to that. The failure to implement, I do think though that my view and my proposal is that when we look at the failure of the transformation project in South Africa, we don't only look at the laws, but we also look at the politics and the political, in the sense that the Constitution itself is a document with aspirations, but those aspirations must be carried out. The Constitution does not create poverty. The Constitution does not make policy decisions. And there is a sense in which I believe the Constitution creates an enabling environment for the transformation project. However, the problem may be lying somewhere. The problem may be lying in or within the realm of the political, within the realm of government that is supposed to ensure that the lives of the people improve, that the excluded are included, that the marginalized are brought in, and so forth and so forth. Right? The Constitution demands that, but someone else must do it. Who is supposed to do it? It is the people that have been voted into power to ensure, and they've been voted into power on the ticket of improving the lives of the people and making this country a better place for all. Are they doing that? There's a sense in which there's been an improvement. There's a sense in which, as you would have seen clearly in the past couple of days, that we failed in that regard. So we just need to be careful when we coin the problem, when we make a diagnosis and a prognosis. We need to be very careful. I mean, in the previous constitutional law lecture, we spoke about this issue. we discussed it, and the discussion, at least my view then, and it is still the same, was that the Constitution does not create a disabling environment, at least thus far. If anyone says it creates a disabling environment, then they need to tell us as to you cannot make sure that people have access to housing. What in the Constitution says that people should not have access to health and so forth. So where is the problem? So we just need to be very careful about that part. Tawanda raises quite a number of issues, mostly which are comments, and I appreciate them. Motion proceedings essentially, you know, that refers to paper proceedings, right? And what I understand, at least Justice Tharon to be saying, and which I agree with, is the fact that at a point when you are going to be, just to put it in very easy lay language, at a point at which you're going to be sending someone to prison, for instance, such a person ought to enjoy the rights that are in Section 12 and the rights that are in Section 35(3). That is very important. So you cannot use a motion once you make motion proceedings a trial, they are no longer motion proceedings, they become action proceedings. You know, I'm sure you know that there's a difference between action proceedings and motion proceedings, right? So you can't confuse the two. You can't make, once you make the other one, the moment you say motion trial, then you are essentially talking about action, and therefore you're no longer talking about motion. It's motion is paper proceedings for all intents and purposes, where evidence is based on your affidavit and supporting documents. Essentially, you know, how evidence is given in motion proceedings is different from how evidence is given in action proceedings. So you cannot turn motion proceedings into a trial. You know, you know, so it's that cannot be done. Kabelo, you raised quite a number of very engaging points, and I appreciate them. And the only thing that I can say is that rights in the Constitution cannot be waived. And that has been decided in a number of cases, and also there's almost clarity in scholarship and scholarly debates about the fact that you cannot waive rights. You know, there is in the Constitution, as you know, what you call a table of non-derogable rights that cannot be limited under any circumstances. So the point of mentioning this is that yes, rights can be limited, but rights cannot be waived. So that difference must be there. So when we're talking about waiving of rights and we're talking about limitations of rights, we're talking about two different things. So there's waiving and there's limitation. Limitation can be done, right? And unfortunately, as it has been argued, and I agree with that argument, the majority judgment should have or could have at least gone through the limitation clause exercise, where it is then says, okay, we are limiting this rights based on 1, 2, 3, and 4, right? But it cannot be that you simply say that your rights are not going to be, I'm going to give you half of certain rights and so forth. So that cannot be done, you know. And if I have not answered all the questions, it's part of the debate that we're having. I may not be able to answer all the questions, and I've tried to get those that I could get. Thank you.
Thank you, Prof. Shai. And
I think probably if I may just ask that I think we've tried. It's now 4 o'clock. So it's been since 1 o'clock, and I know that there'll always be many questions. And if I may just ask, because I have another appointment. Just the last round of questions. And yeah.
Well, what I was actually going to suggest, and now I've
Yeah.
got echo, is Johannes had asked for my input, and I must admit from the outset, I have still not even read this judgment.
Yeah.
I've just had a really hectic week.
Sure.
So I wouldn't be able to comment well.
Yeah.
But what I do suggest is when we do the lecture on the Chapter 9 institutions.
Sure.
Because this whole case really started with the public protector's decision,
absolutely,
culminating in the establishment of the Commission of Inquiry, and so it's gone. Maybe we can use that opportunity to fully canvass this issue better.
No, absolutely.
So even the people who have questions now, maybe we also can hold those questions over. Unless there are absolutely burning questions that students want to ask. I'm seeing only about 5 hands up. So let us just quickly see, of the 5 of you who have your hands up, so Nyameko, Kauli, Octavius, Rudzani, and Tulebona, do you have absolutely burning questions, or do you think they're questions that we could roll over to our discussion on the Chapter 9 institutions, because that deals with the independence of Chapter 9 institutions and the independence of the judiciary. And I think there's a relationship there that we can also interrogate.
Absolutely, yes, most certainly.
So how do we feel, those who need questions asked? Is it imperative, or can we wait?
I've got one imperative question.
Okay.
But it will not be long. It's a brief question.
Yeah.
It's in relation, I don't know, should I proceed?
Yeah, it's okay, proceed.
Please do.
Okay. Yeah, it's in relation with the context of public interest, considering the aftermath of these riots we had. If you can maybe touch on that. Thank you.
Okay, I think okay. Listen, I think in terms of what you've just said, I mean, it's a complex issue, and there are many. That's why I started by mentioning what Bishop Mahova said, and I think for me that would answer your question in a very short and sweet fashion. That what we are seeing, it's a toxic mixture of the reality of this country. That's how I would want to answer it. You know, I wouldn't want to say more than that. I wouldn't want to say more than that on that. I would not want to say more than that, and advisedly so. I'd rather leave it at the fact that it is a toxic mixture of the reality of this country, and it's a very complex matter that should not be reduced only to one reason.
No, thank you.
Another. So I would put it in that way. And just in closing, for me, I would say, particularly just trying to also deal with some of the statements on the chat, that it is my submission that no matter what, whether Mr. Zuma insulted the court or not, I think that we would be treading on dangerous grounds if we were to then say that the rights that he has in terms of the Constitution should therefore be waived or should therefore not be applicable. That's the first point. The second point that I would want to make is that was Mr. Zuma in contempt of court in this matter? And my answer is yes, he was in contempt of court. So I agree that he was in contempt of court. That part I agree with. Then what should have happened is where I disagree with the majority. Thirdly, we should at all times, the only thing that holds us as a country is our constitution. And it is therefore important that we protect it. Where it does not work for us, we need to critique and improve it. The constitution is not a Bible that must be reified. It is a very important document that holds us together, but South Africa is still a very young democracy. And as I indicated in some of the slides, that we are in the midst of a project and mistakes are going to be made, and that is just part of it. But lastly, the constitution and our judiciary are a very, very important part of our democracy, and protecting them it's a no-brainer. It's indispensable that we protect them, and in protecting them, we need to make sure that we give effect to them. Now, if we don't give effect to the rights in the Constitution, and properly so, we are essentially destabilizing our constitutional democracy. And that's my view. And I am really grateful to Professor Stone for arranging this. I really appreciate it, Prof. Thank you very much. And to everyone who participated, I do not have all the answers. I am not a bringer of the truth. I was simply sharing my scholarly opinions with you, and some of them would disagree, and that is a good thing to disagree. Some of you know better in this sense, and that is also wonderful. And I'm really thankful and grateful for your participation. I've learned a lot. You've asked me questions that I may not have considered sufficiently, and I will. And for me, discussions of this nature are part of growing for all of us, including myself. And with that, you have a wonderful, wonderful, sober weekend, because of the fact that in any way everything is closed. So water, tea, and coffee will keep you company, and an opportunity to read a lot. Thank you so much.
No, thank you, Prof. Shai.
Thank you so much.
We are extremely grateful that you could do this for us, and that we didn't realize it would take this long.
Yeah.
And I assure the students that we will pursue this discussion.
Sure.
As we see developments occurring, and when we can then look at it probably more holistically, because at the moment I think there's a lot of trauma related to the case that might be tainting our perspectives and our proper perception of what is actually the consequence or the long-term effect. So thank you, Prof. Shai, and we will then at a later stage discuss this case again in the context possibly of the Chapter 9 institutions, or separately again if necessary. So thank you everybody for attending.
Much appreciated. Bye.
Yes, thank you. Goodbye.
Bye.
Bye.
Thank you.
Bye. Bye.